I just have to hit the right button. It's, works when you do that. By show of hands, how many of you are pastors? Okay, how many of you work for a church? Okay, and how many of you are just out in the world working, doing, being? Yeah. All right, cool. So what I'm going to go over today is going to cover kind of a broad range. We're going to start off with the basic principles of the Constitution, the amendments, and then get into some deep and heavy stuff with case law, that covers all of our rights, essentially, the important ones for us, okay? So first and foremost, the Pacific Justice Institute, who I work for, is a legal fund started by Brad Dacus in 97, and the concept was that he wanted to provide free legal services for everyone. And a lot of times you will see nonprofits in the legal world, but they only handle very large cases. They're on the SCOTUS, the Supreme Court cases, they're up there kind of in the rafters waiting to swoop in and take those big cases. We, and I personally, have worked on everything from unemployment appeals when people got fired during COVID-19 and couldn't get their unemployment, to street preachers getting arrested or ticketed around here when they're protesting LGBTQ parades or speaking freely in Seattle where it's not welcome, all the way up to Supreme Court type cases. We'll talk about one in particular for a spa on the west side that has a policy not to allow men into their spa because it's a women's Korean spa, and they've been targeted, and we're appealing to the Supreme Court to hear the case because we've lost it at the district court, at the appellate court, and then en banc review, which is the full panel of judges that reviews the case to see if they'll take it and review it again. So
I've been there, and I thank you for legislating.
Yes, right?
It would change everything.
Yes, and so this place that I'm talking about, it's very, it's not like a traditional spa where maybe you just have your robe on and there's some nudity. It's full on, and to have a male in there, a transgender delusional male in there, would completely disrupt the entirety of that business. And they're Christian Korean owners. They've got an interest in their culture, in their beliefs, and in everything that they do, and it's just absurd. So that's kind of gives you a flavor for what we deal with in Washington. We're all over the country. We have over 20 offices all throughout the United States. And then where we don't have offices, we have attorneys that we work with who will let us, what we call pro hoc vice, into that state. They're kind of our office on the ground, and then we can represent people from afar. So when our forefathers came over here, they were coming from London, Britain, generally speaking, not exclusively, but generally. There, the monarchy is head of the church also. So you've got the Church of England, you've got the crown. That's who determines religion there. Catholicism was banned and outlawed. Even John Wesleyan, Methodism, had a hard time getting its start. And they were very, it was just the Church of England. And they did not like the fact that both the crown controlled the church and what they could do and when they could do it. And then it was so influenced and intertwined with the government, heavier on the government than on the religion side, that they came here seeking freedom. And so they put into this document all the wrongs that they had experienced in other countries where they lived, okay? So that's kind of the premise. And I don't know about you guys, but we talk a lot about the amendments, but we don't always talk about the actual Constitution. So I'm just going to give a quick primer. This is going to be a little bit boring, so forgive me, but I'm going to go through it because I don't have them memorized, so forgive my head down. Article 1 governs the legislative powers, right? What our legislature can do. And there's 3 separate branches of the government, all having separate powers. Separate but equal is the idea. 2 is the executive powers. That's our commander-in-chief. He governs the Army, Navy, militia, State of the Union, gives pardons. And then we've got Article 3 that we'll be dealing with today, and that's the judicial powers. They have appellate jurisdiction, and then they've got original jurisdiction over ambassadors and consuls. If there's any issue with our ambassadors or ambassadors here, it goes before the Supreme Court. And appellate jurisdiction means that if you win down here, you can keep appealing to a higher and higher court. You don't always get accepted. They're not going to take everything, but they obviously take some cases. What they tend to do is when there's an issue that keeps coming up or some old case law that kind of keeps having issues, they'll take cases that will pertain or answer those questions because it covers a lot of ground for a lot of cases, and it kind of wipes it clean. What we're finding right now is that there's so many appeals for what we call Title VII, the COVID vaccine terminations, that I think that one of those cases is probably going to get heard soon to put it to rest, because the appellate court is just clogged. I mean, with, our cases alone, but much less all the other blue states where people got fired. So that would be one that they will probably take a look at, although not for certain. It goes into Article 4, full faith and credit, privileges and immunities, and some other things we're not going to really talk about today. Article 4 is how to amend the Constitution. Article 6, Constitution is the supreme law of the land, particularly important as we hear rumors of Sharia law and different things, right, that we've kind of heard. So that article is particularly poignant. And then we get into the amendments. There were 12 amendments that were sent, 10 were adopted. The ones not adopted dealt in congressional representation and pay. Wouldn't it have been nice if those had stayed in, particularly limit on how long they can be in there, right? So the First Amendment, which we're all familiar with, and is which our most cherished, and broadest coverage that we have under God and what he's done for us here in the United States, is that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press or the right of the people to peaceably assemble and to petition the government for redress of grievances. So really what this was getting at is that they wanted separation from church and state. And that is obviously a good thing, because you don't want the state into the church. However, what has happened over the last centuries is that the government has taken that to mean church can't come in at all. In fact, there was a case very early on in the 1900s that challenged whether or not a Catholic priest could run for public office and whether or not it violated the First Amendment and that separation of powers. The Supreme Court held that he could, or that anyone of the clergy could run for office, because it's not attempting to infiltrate for purposes of religion, it's for purposes of public service. And so that was a great case that was heard early on in our nation's history. But what has happened is that the legislature, the government, has held so strictly to that separation that they don't allow any religion in. So you think about the 10 Commandments, right? Getting ousted out of schools. And it is very interesting to note, and I got this from Chuck Missler, so I can't take credit for it. In 1960 something, when the 10 Commandments were banned from the schools, all of the social economic indicators in the United States were on the uptick. So from income to marriage to lifespan to children, all of those things were headed up. Took out the 10 Commandments and they all started heading down thereafter and have continued to decrease and decline. So, God's laws are for our good. Respecting God is for our good. And when you push God out, what fills it? Evil. The evil of our hearts naturally fills the space that God is meant to if we push him away. And so our government, in trying to protect against one religion dominating, has now essentially embraced like the atheistic worldview, which is a religion in itself. So Amendment 2, the right to bear arms. 3 talks about soldiers and being housed in quarters. The Fourth Amendment is unreasonable searches and seizures and warrants. Fifth Amendment, the right not to have to incriminate yourself, right? Plead the fifth. It's important if you ever get in any situations with, in particular, criminal, obviously, but even as important in agency proceedings. So if you've got a child and DCYF is on the scene, or you've got any dealings with the Department of Health or anyone like that, don't talk to them. Call an attorney, period. The Sixth Amendment, right to a speedy and public trial. 7, civil suits, civil jurisdiction over civil suits in excess of $20. The Eighth Amendment, no excessive bail, no cruel and unusual punishment. Ninth Amendment protects the rights not specifically mentioned or protected. Reservations for the states is the 10th Amendment, so anything not specifically outlined is delegated to the states. Sovereign immunity, that one is one I'm conflicted about. I think we need sovereign immunity for people to be able to do their jobs. There is a particular type of lawsuit that you can bring called a 1983 suit that gets around sovereign immunity in some instances, not all, but it's incredibly hard to win the court's favor, all of the municipal, the officers essentially of the state or of the federal government. And they generally only tend to stick when you're talking about police, like use of force, things like that, where you've got a policy and a practice of abuse or things that are going on. We tried to establish some of these get around immunity in a variety of cases that were very compelling and it's difficult. I will say that much. It's very difficult to win, but it's there. The 12th Amendment is how the president and the VP are elected. And that was because what happened, John Adams and Thomas Jefferson were running against each other. What it used to be is number 2 just was the VP. But if you've got people who are at odds, then he's your VP and you just ran against him, that's not going to work very well. And it didn't. So that was that amendment. 13, no slaves. 14th Amendment, due process. 15th, right to vote. 16th, federal income tax. Boo. 17th is the composition of senators, elections, vacancies. 19th Amendment was prohibition. Bring it back. Women, the right to vote. Boo. That's a hot take. That's just my personal opinion. Do you know that 63% of the Democratic vote is female? Think about that. 20 is the end of terms for executives, seniors, and reps, meetings of Congress. That doesn't mean the limit on them. It just means when their terms are up. 21, repealed prohibition. 22 is the limit on presidential terms to 8. And then 23 created the District of Columbia. 24, you can't take away the right to vote due to the failure to pay taxes. 25 was the removal of a president. 26, the right to vote at 18. And 27, no increase or decrease in congressional salary until the next meetings of the House. So just kind of a brief overview. I don't know if I had ever gone through each and every single one since I was young enough to not have paid attention. So we're going to talk primarily about religious freedom. And again, the First Amendment holds that essentially religion cannot be forced or taken away or interfered with by the government. And there are so many cases on this. They kind of get broken up into freedom of speech and then laws against discrimination, freedom of religion. There's some amendments to state constitutions that play into that separation of church and state, and a variety of other cases that we'll kind of talk about. First and foremost, those of you who live here may know about the case of Arlene's Flowers. So Arlene, for those of you who don't know, she had a flower shop down here in Richland. I think it's still there to this day, but I don't think she owns it. She had a gay couple who were, clients of hers. One of them came in, said they were having a wedding. They wanted her to do the flowers, and she said, no, I can't. A wedding is between a husband and wife. She's very PC about it, but just said no. So then they sued her, the state sued her, then they sued her also. That went to the Supreme Court. And essentially what came out of that was that they could force her to make and sell flowers for the wedding. And the things that are at play here are, freedom of religion, right? My religion says that that's not allowable, but there's a law that says that they can. So how does the religious belief play against laws of accommodation? And the idea of laws of accommodation are, so you get back to times when there was segregation, right? You had blacks and whites, separation of multi-ethnic individuals, and then white people. After that, they made laws about a public accommodation. So the most famous one, I forget the name of a hotel, but it was a hotel that would refuse service to any African Americans. And that case went to the Supreme Court, and they said a place of public accommodation, somewhere that is open to the public entirely, cannot deny service on the basis of a protected classification. So if you're female, you have to lend them a room. If they are African American, you have to let them a room, whatever it is. Well, then you add in, and again, the idea behind this, remember the LGBTQ movement when it was they're born this way? Remember how hard-hitting that was? It was a huge thing. You had to get it there in order to get it a classification that's protected, right? Because if you're born female, now we can be born whatever we want, but if you're born female or male, or if you're born up into a certain ethnicity group, right? Those are all things that are beyond your control. It's not a choice, it's how you're born. So there was a huge push first to get LGBTQ individuals born this way, which is still not proven. There's no way to prove that. If you looked at someone, there's no way that you can identify how they attract if they're dead, right? Everything else you can. So they got status as being protected individuals. With Arlene's Flowers, what she was saying and what kind of the thrust of a lot of these cases is that I sell him flowers all the time. What I'm saying is I cannot condone a marriage and make these flowers, which are my artistic expression, for them. But they held that flowers were so fungible that she didn't have a case. She lost it. There was another case in Colorado called Masterpiece Cake Theater That case, they held that he did not have to make the cake because it was not so fungible. It was, I think it's Masterpiece Cake Shop, right? So this fellow is a masterpiece cake worker. It's a piece of artwork. He's doing this, the design, which, in my mind, arguably flowers are the same. You're using your creative expression. And for, a localized event type thing, it's not just like buying something off the stand. So Masterpiece Cake also had a lot of discriminatory remarks made by some of the government officials, which really helped the case out. That was their slip up, and it really kind of pushed it over the edge to win or to get that case in favor of the owner of the cake shop. So that went for religious freedom, whereas Arlene's Flowers did not, and that's a case we're still coming up against. But the series of cases that the Supreme Court lately, and it really, when you think about how God, he counts every day. He knows when he's going to take life and when he's going to give life. When he took Ruth Bader Ginsburg, who's, infamous on the court, when he took her and we were able to replace her and get a conservative court, that has been such a huge blessing. I cannot imagine where we would be right now with our president, just how much pushback there is if we didn't have a Supreme Court that was for religious freedom. And really, they're just textualists, right? They read the text of the Constitution, same with like Roe v. Wade, when they overturned that. There's no constitutional right to abortion. You cannot possibly read that into the Constitution. That is for the states, and the Fed needs to stay out of it, right? It should be outlawed, period, but it essentially went back to the states for their discernment. 303 Creative was a more recent case, and that was an individual who makes websites for weddings. Again, keeps coming back to the wedding, the gay wedding. And so she designs these websites, and a gay couple approached her, and she was saying, no, I cannot design this site for you for that purpose. And the Supreme Court held in her favor that this was enough of a personalized artistic expression in designing these websites that she didn't have to. That would have been compelling her to violate her First Amendment right to express her religion as she sees fit. Keep in mind, in each of these cases, what you're fighting is the laws against discrimination. So in Washington State, that's the Washington Law Against Discrimination. It's Revised Code of Washington 49.60. And it says that in a place of public accommodation, you cannot discriminate, right? So on the basis of X, Y, and Z, all the protected characteristics that we went over. And you're fighting this in all of these cases all over the country in that state. The next case that just came out, and it's an amazing case for therapists, especially because you see so much of the transgender ideology issues that are coming up. It's like the sexual deviancy and the spirit that resides over America started with sexual freedom, right? For everybody, every person, women in particular, in the 60s and 70s, and then you get into homosexuality, and then you get into transgenderism. It's like the level, it just keeps upping itself. And the reason that it gets so much hype behind it is that these nonprofits that support these, different endeavors, they only get money if they've got something to push, right? Once it's already been attained, once you legalize same-sex marriage, there's not really much more for the nonprofit to fight. So they have to move on to the next thing, the next, insane proposition. And so it just keeps getting worse and worse and worse and worse. And it went from, transgender population went from, 0.0000% of something to it's exploding now. You're seeing it everywhere because it's the next thing. And once you get an idea planted, especially in the young people's head, and it can make them different. Everyone wants to feel like they belong, like they're special, but everyone wants to find they're special on the outside instead of the inside. And this is what these children are grappling with. So in this case of Childs, she's a therapist. She engages in talk therapy, which all therapists arguably do, but it's centered on talk therapy, not shock therapy, not other kinds of, back in the day, they used to literally castrate and sterilize people who were considered not, mentally insane, et cetera. So the court was trying to distance itself from that and say, this is just talk therapy. It's what she's speaking. She's not doing anything else here. And you can't compel her speech, right? That's the issue here. It's not only against my religion, but now you are compelling my speech. You are compelling me to say something that I don't agree with. And that's a big deal, you guys. If you think, having to speak someone else's message is a big problem, especially when it's our government that is telling us. And that's exactly what our forefathers, that's why they have this. You cannot abridge freedom of speech. We normally have thought of it as, if I go out to the corner, I'm allowed to speak, right? I'm allowed to say what I want. You can't tell me what to do. But now you've got licensures of various types. This is a therapy license on top of it, where the state was pulling her license because she wouldn't speak the message that they approved of. And so this came up before the Supreme Court, and they said, nope, you can't force her to speak this message, which is brilliant. I mean, that protects freedom of speech for our future generations in a big way. Had that gone the other way, and again, you're looking at different interests here. The state has an interest in its mind of protecting these people, these children, etc. And again, a therapist, if you're grown, you just don't go to that therapist. So at the heart of the matter is child talk therapy, and where a child's parents are deciding where they're going to therapy and trying to get the child away from that ideology and that mindset. That's where it comes into the crosshairs with the state. The state wants to uphold it and say, no, they're a girl, even though you think they're born a boy, like that mental illness, for lack of a better word. We are dealing with this freedom of speech issue in our Olympus Spa case that we talked about earlier. What happened in that case, it's just fascinating how all of this plays out. When you're the aggressor and then you play the victim, this is what I usually find in these kinds of cases. So there was a transgender person. He actually grew up in a homeschooled home, went to church, textbook Christian family, although I don't know the inner dynamics of it, obviously. Grew up, was confused, started going to college, decided that he was a woman, started endeavoring to become a woman, and called, we didn't know it at the time, but he said he went to the spa and was denied service. So my client's looking up all the logs because they take you, the second you come in, you get a screen, you sign in, and he never showed up. He was never there. But he told the Human Rights Commission that he was denied entry. Well, then he walks it back and says, oh no, I just called and they denied me. They told me they wouldn't, serve me if I came in. Well, we looked through all the call logs. Again, no, didn't happen. So he's out there, he was just trolling, trying to figure out a way, or maybe friends were going and he looked at their policy, I don't know. But anyway, he reports our clients to the Human Rights Commission. They open an investigation based on the website. They say the language on your website says that you won't allow preoperative transgender women in. You have to change that. And here's all the things that you have to do. Change your policy. So again, speaking a message, your website has to agree with our message here. We lost our case right out of the get-go. When you file a case in federal court, sometimes instead of answering, the state will just file what's called a 12B6 motion. It dismisses the whole case. We lost there. We appealed to the Ninth Circuit. We lost there. Then it went to that en banc review. And the irony, and it was very inappropriate language, but one of the judges, Van Dyke, who's very conservative, he's conservative, not very conservative, but he basically said this case is about explicative, and women don't want explicative in their private personal environments. And really, all the other justices were like, oh, we don't use this kind of language. Oh, pearl clutching, as he called it. But really, that's the truth of it. When you get right down to it, it's about private parts and where you don't want those private parts in where females are. And so we're applying to the Supreme Court, but essentially what happened was that they forced our clients, rather than litigating it in state court, we had to agree to change the website language and to say, we won't discriminate on the basis of any protected class, essentially, which changed their language. They had to speak their message. And again, we tried to make the case that this is a service, that this is very niche in its application because it's Korean, because it's jjimjilbang is what they call it, but we lost. And then we lost to the Ninth Circuit, now we're applying to the Supreme Court. But you can start to see, if you're a business owner in the world, especially on the West Side world, there's no end to the insanity. This isn't like people are just coming in to get a bag of chips and things like that. When you provide specialized services, you're really in the crosshairs. You are at risk in your business. So we represent people towards that end. Freedom of religion, it's interesting. One of the worst cases to ever happen to freedom of religion was a case called Smith v. I think it was Department of Unemployment. It's an Oregon case. And what happened was Smith got terminated because he smokes peyote. And then he couldn't get unemployment because he smokes peyote. And that's part of his religious beliefs, right? And this has gone round and round in different kinds of religions. But he took his case all the way to the Supreme Court to say, my religion allows me and requires me to smoke peyote, but this law makes it a class 3 drug and I can't do it and I can't get unemployment. That was kind of the thrust of the argument. And it got up there and the Supreme Court said, this is a neutral law, right? So it's not targeting religion, it's just a class 3 drug. We're saying you can't use it, period. We're not gonna favor religion, we're not gonna be against religion. It's a neutral law and it's got general applicability. So it generally applies. That's the same type of argument that got used in Olympus Spa case, right? This Washington law against discrimination is a neutral law, doesn't talk about religion, and it's generally applied to all businesses who are open to the public. So if you are that kind of business, you have to allow any kind of person in and speak that message. For this business, again, it's not exactly open to the government. And here's the thing I want you to think about. They're okay if you discriminate against men, right? They didn't say anything about, like, you have to let everybody in. It's fine if you want to just let women in. But for this group who identify as women, you have to let them in. So it's really not, it's generally applicable, but it's not, well, it's neutral, but it's not generally applicable because it only applies to these types of groups. Men are excluded from everything. And I just find it so ironic how it's always men who get excluded, you know? It's like, it's okay to discriminate against them, but nobody else, none of the other lesser classes. You cannot discriminate on the basis of gender. That should be it, period. So that's just one way that neutral laws of general applicability can really hamstring religion. We saw that during COVID-19. There was a case called Tandem v. Newsom. Do you remember when all of the governors were requiring churches not to meet, or you couldn't meet in houses, in groups of families of 3 or more? Meanwhile, he was at French Laundry up in Napa Valley. Did you guys see those pictures? Remember that? Yeah. Wild. And so that went to the Supreme Court, and they were allowing all different other types of activities, but not church meetings. And so again, that infringed on freedom of religion because it was not generally applicable. It specifically targeted certain types of activities that were okay and others that weren't. Therefore, the government got to be in the driver's seat and decide what was okay and what was not. And that was just one step too far. So that was a really great case, and it helps us with Olympus Spa because, again, the male dynamic of that. You can discriminate against males, just not males who identify as females. That's the linchpin for that case, and it's insanity. Another interesting item, I guess, if you will, that we're dealing with are what are called the Blaine Amendments. Blaine Amendments were amendments to state constitution, not federal, but state. And it was a senator who passed it. And essentially what it says is that government funds cannot be used for, it prohibits government funds of being used for sectarian schools, so like private schools, right? It can just go to the public schools. Because A, the public schools want to keep that money, and then B, his argument was it would run afoul of separation of church and state, because now you've got the government funding particular types of churches. Well, this has come up recently in a lot of cases because they've been talking about school vouchers, right? So you've got the school voucher, the parents get to decide where their kids want to go. In Montana, they have such a large state, and the populations are so sparse that they often will not have schools in an area of no public schools. So parents got vouchers to choose which school their child could go to, and they could go to private schools, but not religious private schools. And so they took that case up, they won it, and it basically kind of undid the Blaine Amendment in Montana. We just had a case with our client, Chad Rose. He is disabled, and he was on DSHS benefits. He was in what I would call tier 3. And he qualified for a scholarship for certain credits, which he was taking at, I think it might have been Liberty University, or it was a Christian university, and he wanted to be a Christian counselor. They didn't have an issue with the fact that he went to a Christian university. It was that he wanted to be a Christian counselor, and because that was sectarian, they would be violating the Blaine Amendment and separation of church and state. And so we sued them. They backed it up real quick. I will say this about our government here in Washington. They know the tides are against them, and they will do anything they can to stay out of court right now. They backed it up quick. And the Bible says, be amenable with your neighbor as you walk to court, lest he turn you over to, I'm not quoting it exactly right, but it's, settle the matter before you get to court, lest you lose. And so we settled it with him. They ended up boosting him up to this top tier. He got the money back that he had to borrow. He can still go and pursue this degree. But, they were still at the lower level at this agency. They were fighting it. and they basically, like, they would not give him the money. That is based on case precedent, which is a case called, where is it? Locke v. Davey. Yeah, Washington State. And Locke was a gifted kid out of Seattle. He had a full ride scholarship to a religious school and wanted to be a pastor. And he could not get that scholarship because it was a state-funded scholarship because he wanted to be a pastor. And that would essentially be the government funding religion. And so they wouldn't give it to him. That was during the liberal Supreme Court. They took it all the way up. Jay Sekulow, who has ACLJ, does great work. He took that one up, and they lost. And so that's what's on the books. And that's what we were trying to get overturned, because that would have overturned the Blaine Amendment in Washington State. But again, they were willing to work with us, and you have to have damages in order to have a cause of action. And they paid it back, and they were willing to do all these things, so we knew it wouldn't really go anywhere. So we settled it. But they are quick to back down if they know it will go against them in the long run while there's a conservative Supreme Court. So Blaine amendments are definitely something we're fighting for, and to get overturned in Washington State. So if any of you hear of any of, or experience any of that, let us know. Parental rights and free exercise, that is a big deal right now, especially, the government thinks, and Hillary Clinton admitted this once, like, the government's in control of your kids. They're ours. They don't belong to you. They belong to us. And again, the idea, like, they belong to God. We're the stewards. But when you have a government that doesn't believe in God, then they are God. And that's what so many people look to government to be God right now, And it's problematic. I have never seen DCYF, and that's our local state agency. I've never seen them get it right. We have a case I'll discuss in a minute, but they denied this Christian woman a foster license. They are 200 homes short of what they need to house every foster child they have, just on a one-to-one basis. They could do more in one home, but they're 200 beds short. They have an act where it's keep families together. They will keep babies, young children who cannot care for themselves, in meth-addicted homes. The death rate of children under the age of 3 is up 44% in the last 2 years, because you're keeping them there, but they'll pull them when they get older. Think the older kids who are gender dysphoric, et cetera, they will pull that. We are a sanctuary state. Our police can't even report a runaway child from another state if they're here seeking sanctuary because of gender dysphoria. So they can't even let mom and dad know in Montana, Idaho, some other state. It's wild. But the idea of parental rights, they still hold strong. The first case to ever the most recent case to come before the Supreme Court was Wisconsin v. Yoder, and that was the Amish families in Wisconsin, and they pull their kids at 8th grade. And the state said, no, you have to keep them in. And they said, no, we don't. And so it went to the Supreme Court, and the Supreme Court at that time said they have a right to determine the education and the lives of their children. They could pull them out if they want to. So that really firmly cemented parental rights. Mahmoud was a recent case, and again, it's interesting. You can't really get courts to side with Christians, but they'll side with Muslims really quickly. So Mahmoud was just decided, and there were Christian parents. It was a group of religious individuals, but I feel like Mahmoud was particularly chosen to because the attorneys knew that they would get favor with Muslim plaintiffs, and also because then that would, foist our acceptance of the Muslim Brotherhood in America. But what was happening, and I forget what state this is, it might have been Colorado, they were sharing a lot of LGBTQ materials, books, etc. in the classroom. It's woven into the teachings now. It's not just like, we're going to have this day where we're going to do this teaching, you can opt your children out. It's thematic. And so they were pulling their children out and giving what we would call accommodations for families who didn't want their kids in this kind of topical discussion. And so many kids were having to leave the class that it was deemed to be disruptive. And so they took away that accommodation and said, nope, you just have to stay. So they took this case up, and the Supreme Court, our current Supreme Court, said, no, parents have an interest in determining the education of their children. You can't do that. You have to honor their wishes. And so you either change the curriculum or let them be recused, because again, they're not telling the school what they can and can't teach. They're saying, you let them get out if they don't want to be in. And that, is kind of a middle ground in my mind. It's, okay, we can't tell you, we should be able to because we're citizens, right? But the courts aren't going to tell the government what to do. That's the separation of powers. We're not going to tell you what to teach, but if you're going to teach that, you have to give parents an out and respect their rights. It's kind of a middle ground. Another case that just came down recently is Mirabelli, and that was where parents were being misled, or in California, if children are identifying differently at school, they can't tell the parents. They have to hide it from the parents. And that was passed by the governor. And so all these parents, there was one Mirabelli parents in particular, where their child was transitioning at school and they were kept, that information was kept out. What they call is they couldn't out the child to the parents. And it's, again, that idea of parents being on the outside, schools being on the inside. And, I kind of go back and forth. We don't need to demonize our schools. We could easily bankrupt them by keeping our kids out. But you have a lot of options if you are going to put children into school on what you can sit down with the teacher, the principal, the administrators and say, this is not to be taught to my child. Here's the reasons why. This is not to be taught to my child. And I've got the case law to back it up if you want to challenge me on this, and it works. It does. They have to abide by that, even in Washington State. Coach Kennedy was another big movement for freedom of religion, freedom of speech, and free exercise. If you guys remember, he was the coach over on the west side, and it was interesting, by the Lord's providence, I was friends with someone who was on his PR team and got to be there for that game and met him and everything. And it's interesting, that case is huge in the legal world. We will couch on that case forever. He was so beleaguered and done and over it by the time he got there. It had been years. He was over it. He just felt ostracized and kind of hung out to dry in it. Because, the attorneys, they get the millions of dollars in legal fees. He just got his back pay. For a part-time coach, that was a lot to have gone through for that. He did get a book deal, I think, and other things, so I hope that it was, the Lord made it up to him. But, for us, that case is brilliant for him. He was and I was like, man, no, you don't understand, what you have done by doing this for me, for others like me. We can cite to this case now. It's such a huge deal. But he would go out and he prayed after the game. He would just take a knee and pray, and the whole thing was you can't do that on our field. With you're the coach. It was after the game. He didn't require anyone to go with him. They could join. And, after all this process and much deliberation by the Supreme Court, they said, no, he can. He's not representing the school. It's after the game. He's not asking anyone to come and join him. And so that was a great case for freedom of religion, free exercise, rather. And what a lot of you probably are curious about or want to talk about is church autonomy doctrine. That's the idea of the church being able to do what it wants and not have interference from the government, right? So for everything from who you hire to what kind of, religious requirements there are to work inside of a church or even a school or some kind of 501c3, 508c1a adjacent ministry, some kind of ministry, what you can and can't do. This gets into that idea of the government cannot tell churches what to do. And it has straight up stayed out of that area. It will not come in. The closest thing that we have found issues with churches are zoning issues. They will usually pick at churches for zoning problems or what they perceive to be the government, the municipality usually for zoning issues. But when it comes to church doctrine, one church suing another church over something, and there's some cases like this, but the court is just, they will put up a wall. They're not going to judge religion one against the other. They view it as very much not their position. And thank God they do, right? Mm-hmm. They shouldn't step their toes into it. Recently, what we've seen locally, which is exciting, a lot of great cases come out of Washington and Colorado because there's a lot of crazy people, and all this craziness. But it was the Union Gospel Mission, Woods v. Union Gospel Mission. And as we all know, UGM is here, Yakima, I think it started, Washington State. They originally ran, I think, a soup kitchen. They've got some homeless shelters. They also started adding on legal services, right? So as your ministry expands, what is ministry and what is not? And so what happened, they had this intern, Woods, over in Seattle. He interned, and then he applied for a job, and he met with the executive director, I believe, of UGM, and they were talking over potential employment. And he said, well, I'm bisexual, or I'm attracted to men, or I might be, or, it came out in the conversation. And so in applying, he told him, you can't work here. Like, this is what we believe. We're spreading the news of Jesus Christ. Here, he gave him other contacts to get jobs, you know what I mean? But I'm telling you, there is an axe to grind with LGBTQ individuals, because you had better accept me, or I am going to litigate you into oblivion. There's just this, I'm not sure. It just is this, like, you have to speak that I am okay. You have to tell me that I am okay. My level of acceptance is predicated on your acceptance of me. It's very odd. So anyway, he comes in state court, and that's not a great place to be in Washington State if you're fighting any of these kinds of issues. You want to be in federal court. As my boss says, they're prejudiced, but they're less prejudiced about their prejudices. So that's a good place to be. So UGM gets sued, and the Washington Supreme Court holds against them kind of on a narrow issue. It says, we believe this is discrimination, but first it needs to be determined whether or not a lawyer is a minister or not, because the ministerial exception, which is hiring co-religionists, that is, dependent upon whether or not this person is actually a minister. In the meantime, they applied to the Supreme Court to get review. The Supreme Court said, no, Alito thought that they should review it. The other justices said, no, not until they take it back down and decide if it's a co-religionist, if it's a minister. The state dropped it quick. Woods dropped it quick. And you've got all of their nonprofits in the background, like Southern Poverty Law Center. Maybe you've seen they're in the news lately, what they're doing. Those types of backing, they're like, don't, stop. We're not going to get a good ruling up here. Don't take it any farther. So they dropped it. Well, then Alliance Defending Freedom represented UGM and brought suit against our state AG in federal court in the Eastern District of Washington. The judge dismissed it, like happened to our Olympus Spa case. They appealed it. The Supreme Court said they have standing. Hear the case, essentially. Hear it. Don't dismiss it. It went back down. They granted an injunction, and they said that, this is a minister function. They have shown and they have proven that even if it was the state tried to make the argument that, like, we're not going to sue them. We have said that we will back up on this. We're not going to take it. And they're like, yeah, but you did. And there's other jobs that you have not said that you won't sue them over. Like, they have IT quality assurance people. They have people who serve soup. They have all of these other jobs that you're not saying you won't pursue litigation against. So, they let it go forward, and UGM has won that they won it at the district court, and they won it at the Ninth Circuit. And whether or not the state appeals it to the Supreme Court, that would be a huge loss for them. So I hope they do. What it's done is expand the definition of minister. And what I've told Calvary here, and I tell all of my, anyone who asks, if you have a nonprofit and you have people working for you, write out that they are a minister. Give them duties that grow them spiritually, and give them, a piece in ministering to whomever you're ministering to. So whether they lead prayer, whether they recite scripture or something, they need to be invested in ministering to the people around them, to the people that your ministry serves, and that helps protect you. Like, it does so much in the spiritual realm and then in the physical realm too, right? So that is kind of all I had mapped out. I wanted to go over some broad things, and I was hoping you guys might have some questions that we could finish off, things that maybe I didn't touch on. Yeah.
So two things.
Yeah.
One is, were you involved with the lawsuit that it was a discrimination because a religious organization received an application from someone who was non-religious, and they were denied, and they took that to court to try to force that religious organization to hire them, even though they did not believe that.
I mean, I would say that one is akin to the Union Gospel Mission one, where they had the ministry. I'm trying to think if we have anyone directly, I don't know all of our cases all across the United States, but in Washington State, we represent those kinds of people. And again, the government is not going to step in to church doctrine, to church practices. Like, if you're a straight up church, right, that is just like taboo, off limits. One other thing I want to discuss, I'll come back to it, but I'm not quite sure. Maybe I was, maybe I wasn't. Only if it went well.
I believe the church organization won that litigation.
Yes, it's possible.
Because it was a church organization. So it would be like a secular person coming in.
Yeah, totally. If someone walks in, you don't have to hire them. period. You know, even, and again, that's why it's important as a nonprofit that you know, outline kind of what you're going to do, what you're, you know, who you're going to hire and what you're not.
So the other thing was that I actually know of a woman whose daughter went to college.
Mm-hmm.
And she, as you know, most colleges require freshmen to stay in the dorms.
Mm-hmm.
You're not allowed to.
Does she have to stay with a dude?
Huh?
Does she have to stay with a dude?
Yeah.
Yeah. Mm-hmm.
They roomed her with a dude,
Mm-hmm.
and she found out about it, and they forced her. They said, well, you can, we don't have any other place for you.
Oh
So-
yeah, you can always, and especially again, public accommodation. You can apply to the university and say, I've paid, I'm a student here, I've been accepted. I need an accommodation for my religious beliefs that I cannot dwell here with this person. Also, I do not feel safe. I feel very, even if it was a female, who was a lesbian, like I don't feel safe in this situation. Safe is almost a better word to use because then it's, it really is a safety issue. They make me feel unsafe. So I do not blame that at all. Like, that girl for, hopefully she got out of that school if she didn't, but if not, out of the room, period. So I can help. I mean, you can send them my contact info.
I'll talk to her about it.
I'm not sure. But yeah, I mean, like universities, they're very liberal.
Yeah.
They would put girls with boys, girls on different floors. They don't care. They're there to take the money, get the money, keep the money. Yes.
I feel like there's a lot of recent panic in Washington State about parental rights, and there's recently been legislation passed about things that public schools do and don't have to communicate, and how much time they have to communicate those things. And I was a public school teacher for 7 years, and then I had kids, now I'm staying home with them. So I feel like sometimes some of it is like alarmism that's drummed up and turned into a flurry, but some of it there's real concern for. So I guess I would love to hear you talk about parental freedom and rights as it comes to like disciplining my kid. Like if my 3-year-old's acting up in Costco and I spank him, is he gonna get taken away?
Right.
Or also just parental freedom and rights as it comes to like, people say if you have a transgender kid and you're a Christian parent and you say, no, that's not what we're doing, your kid's gonna get taken away. I guess to put it concisely, how much of these types of concerns are alarmism in this state and how much is founded?
Right. I think it's all kind of alarming, like to an extent.
For sure.
Right. What happens with public discipline is that you get somebody who is, doesn't think that children should be disciplined, and they're gonna, call you out. What I would do is there's 2 things that I would suggest. One, you have a wooden spoon or something that represents spanking in your home, whatever that is. Even if it's your hand, that's harder in public. So I would make it a wooden spoon. That's the spanking tool. That tool goes into the purse, and you show them, this is in my purse. You will get it when we get into the car. You do it, and you can just kind of, give a flick of the wrist out of the purse. And the other one is a pinch, like a quick pinch, or like by the shorts at the back of the hair, like a lean in with that. Also, and this is just purely mom advice.
You must be a parent,
I am,
aren't you?
mom. But like squeezing on either side of the neck on this neutralizes. I had a coach who used to do that to me when I got a little too owly, and so just kind of, that will neutralize them quickly. I would not spank in public.
Okay.
I would have, it depends on how old they are, but make sure they know these are my expectations if you don't. And, part of that is, making discipline. I often felt bad about disciplining, very, very bad. Now I look at how my kids behave, and they have a certain respect and healthy fear of, certain things they shouldn't do. It's good, so that's what I would say there. As far as the schools go, they want to do everything depending on where you are. There are a lot of great school teachers here that are not necessarily with the agenda. If you walk into your child's room and that teacher is wearing a flag, like I saw one teacher doing, you had better ask for a transfer real quick. You don't even have to be specific about it. And so what you have to do, and do it right out of the gate without any fear, is just lay down with the administrators. These are the things I want my child opted out of. If that teacher isn't a good fit, please let me know and we'll opt them out. My daughter really wants to go to public school next year. That's kind of a lot for me to handle. I'm going to have a sit down and say, if you guys have opposite gender identifying individuals in the school, I want her opted out of PE. She'll not be changing in front of anyone. She won't be sharing a locker room. You can do whatever you want with them. I'm not trying to change your policy. I'm not trying to, create a big stink. And there's a big Facebook post you guys might have seen about Pasco, Chiawana recently. Anyway, you can do what you can do to change it. And what we can do to change everything is have every kid pulled out of PE, as many as possible. Like that case I went over, I think it was Mahmoud, all of the parents pulled their kids out of it. And then it forced the issue to a head. The Supreme Court just heard 2 cases on transgender in sports. Little, I think was Utah or Idaho. I think it was Little in Idaho, and then another one on the East Coast. And so those opinions haven't been issued yet, but during oral argument, the Supreme Court really sounded like they were going to come down on the side of not having transgender. It's always guys. Girls aren't trying to play boys' sports, which should tell us something. Not let them in. So
You don't find girls wanting to go into guys' locker rooms.
No.
And guys want to go into girls' locker to see naked girls.
Totally.
And
Yeah.
And why hasn't there never been a definition of a man?
Yeah, they keep changing the definitions, and then it's like you just keep adding people. And one of the arguments by the Supreme Courts in one of those 2 transgender cases, was this language is not in the definition under this state law for, I forget if it was transgender or whatever it was. And they're like, this really doesn't even fit. You've kind of given us an easy out, is what I heard him saying. We can just decide it here, because the legislature, again, they're going to read whatever the legislature does. And if the legislature's wise about how they label things, they can kind of give an out. So, yeah.
Yeah, I touched on the COVID scenario there. I was working for the state and got let go because I wouldn't get shot up.
Yeah.
And then they said they wouldn't honor my religious exemption for it, but however, a year and a half later, they decided they would honor my religious exemption and then hired me back.
Yeah.
Couldn't get unemployment because they said I was putting myself in a
Oh man, I wish
position
you
that
would
I
call
was
me.
not.
I haven't won cases on the firing stuff yet, but I've won all my cases on the unemployment
Yeah, I
issues.
just wanted to know, is there any positive movement at all in that regard, or no? Or?
Oh, it's bleak. We are fighting. I had 10 plus cases, hundreds of clients. You can only take so many. We have lost every single case. When I originally started taking cases, I took a lot of firefighters and police officers, because that was an honorable, in my mind, that profession. They were out there when we all didn't really know what was going on. They were, facing the front lines. A lot of my guys were the ones who showed up to I think it was Kirkland where it first broke out. They were there on the scene. They were the ones putting together policies, knew what they were doing, etc. So I thought this is the obvious choice for a plaintiff, because if anyone's prepared and can safely perform their jobs while masked, while doing all these things, that's the one. Lost that case because I didn't have an expert. They had an expert who worked for Seattle Harborview. He's a UW teacher, epidemiologist, all the credentialing, So I lost it because I didn't have an expert, and they believed the expert over on summary judgment. We didn't go to trial. Then the next one, I got an expert. Then they said that guy wasn't an expert, and we're not going to use him. Then the next case, I got another expert, and he wasn't an expert. We're not going to use him. Then I got another expert, and then he wasn't an expert. And it's just can get no relief. Then I had plaintiffs who were not doing any kind of health care, who were in the gambling commission. They worked for the state's gambling commission, right? Not a necessary service, not something that's really involved. You're just kind of working on programming. You can always wear masks. They were letting in people, the tribal partners from the casinos, they were letting them into their, I forget what they call them, but kind of smaller areas where they test the gambling equipment. They were letting them in there unvaccinated with certain precautions, but they couldn't accommodate their own employees. And then the argument was, there's too many people asking for the exemptions. That's too many people to accommodate. It's too dangerous. I'm like, so you fire them? That makes it easy? Fire half of your population, and then that makes what you're doing easier. So not yet, but there is one of my cases through another co-counsel is being appealed to the Supreme Court. I just finished briefing at the Ninth Circuit in 2 or 3 cases. The scary thing about the COVID-19 cases is that they started judging religious beliefs. The courts have always, there's kind of a 2-prong test that they use for accommodation. You experience this. You have to tell them what your religious beliefs are, and then they say, okay, yes, we believe you. Now we get to whether or not we can accommodate you in your job with masking, testing, whatnot. There's a couple cases where they held they didn't believe that these women had sincerely held religious beliefs. I had 4 clients, 4 different religions, all worked for the Department of Financial Institutions, remote. They weren't even in the office, and they didn't bring people back till like 9 months after they fired them. They all got fired, and the judge dismissed our case, saying that, yeah, they don't have religious beliefs, which is
Well, that's the
wild.
thing, they didn't say I was fired.
Yeah,
I
they
worked
just-
till they told me to leave.
Uh-huh.
Am I fired?
Yeah.
They go, no, you're making a decision to make yourself not basically
Yeah, no.
worthy to work here because you're not.
That's wordsmithing of the
Yeah.
first rate. It's not. Yes.
So you mentioned parental rights.
Yes.
So working with church youth
Yes.
kind of takes that and puts it on a different plane there.
Right.
So schools aren't allowed to out their kids.
Mm-hmm,
What about youth groups or Sunday schools?
Right. So, and we kind of got to, I skipped over a few things that I wanted to say there with the initiatives. They recently, in Washington State, I believe, made ministers mandatory reporters, or like youth group, for abuse and things,
Yes.
which is a huge
Yes.
breach of like that confidentiality. Now, should we report? Probably. But when the state starts to tell religionists what they can do, that kind of riles our feathers. So with that, like I've gotten calls from teachers who run groups where mom and dad are really liberal individuals, but the kid is going to youth group, and it's kind of gone the opposite way, where good doctrine was being taught, and then it was carried back home, and then mom and dad got upset. Are you thinking more in the vein of if there's a somehow identifying child and what that risk would be to?
Somehow identifying a child showing up
Mm-hmm.
and then saying, I was told that that's
A sin.
a sin, essentially.
Oh, yeah, you can tell, you can say that.
Or that the child is identifying this way, but the parents don't know.
Right, oh yeah.
And then having a conversation with the
With the
parents to
parents,
say,
yes.
hey, did you?
I would absolutely making sure, like, cover all bases, like if you talk to the child and they're like, oh, I didn't tell mom and dad because X, Y, and Z. I mean, if the kid's coming to youth group, right, they're still tethered to biblical principles. If they've got mom who's a crack addict and out there, then I don't know that that's going to do as much good. That's more like keep the relationship going. But mom and dad, absolutely, if they're involved, need to be notified. If they're, and that is not, you don't have to report that, but it is wise to. And also, the state can't come in and tell you what to do in that space. What to say, what not to say, any of that. They're trying with this ministerial exception, but it's fightable.
We're on the west side.
Oh, yeah.
And very, very deeply
Totally.
liberal.
DCYF would be.
Yeah. So what moral kids that go to the public school system, that their teachers are all identifying and wearing
Totally.
the flag, so to speak. But the families don't necessarily believe that way, but the
Right.
students
Right.
are getting confused.
Yeah. Then
So
you
they
need
come
to
in and then it's
hammer.
like, do we have a conversation with the parents? The
Yeah.
students then feel like they've been outed, they go to the teacher.
Totally.
And so
Drive
we
it.
put in the church.
Yeah, unless
in
the
a
child is
school
directly
scenario.
telling you that they are cross-dressing at school or something, you know what I mean? Where it's like, okay, this is reaching critical mass. If it's just messaging, then I would every week talk about that messaging and recorrect it and reprogram it. Because again, we send our kids off to 8 hours of school per day. They're hearing these messages from this person who is the primary person they see all day. Now, I'm not up for parent guilt or anything like that, but that's abdication. If you abdicated your role, then you can't be surprised when you're usurped in the level of, who's accredited to what kind of authority. So touching base every week on those hot points and redirecting to what the truth is in a way and giving them the tools too to go and speak the truth. They have freedom of speech rights in school. Kids have, there's been a lot of cases also where kids are wearing shirts or they're saying things, and fighting back against that. And we're here to help for that too, especially in Washington State. To kind of answer your question, two-part, Department of Child, Youth, and Families, which used to be CPS, but they rebranded to give themselves a new look. Agency law is really problematic. If you'll notice, everything we went through in our talk, nothing talked about agency law, right? But agencies the legislature creates this new law, and now they need to create an agency to manage this law. Agencies do not follow separation of powers. They are their own executive, legislative, and judicial branch. They've got a head. That head usually makes some of the laws. They will, we had one time a situation where there was how was it couched? When you're in with DCYF, it's not really plaintiff and defendant, it's just the state kind of bringing something against you. It's called in re, whatever your name is. But the woman who was represented DCYF, so she was kind of their executive. She had written the Washington Administrative Code that we were discussing, and then she was the one who was going to decide what happened before we could appeal to an administrative law judge. And so I'm on there, and she's got another attorney with her, and I was like, so were you on the committee that wrote this law? Yeah. And you're going to determine whether or not this goes anywhere? Yeah. And I was like, do you think that is an issue with your, yeah, like, how are you going to, decide this and not have it be a separation of powers issue? And, she's like, her attorney pipes in, we don't think that's going to be an issue, but we'd like to take a 10-minute break. So they take a 10-minute break, and they come back, and they're like, we're just going to push pause on this for a minute, and then it just went away, just completely went away. So agency law is like the wild, wild west. What they will do if you talk to them, especially with children, do not talk to DCYF. If you get involved and entangled in a situation, I've personally been involved in situations. My daughter was 2 months old. We went to the hospital. They wanted to catheter her. I didn't want them to. They called the cops on me. I had to run to my naturopath. Terrifying situation. Don't place yourself in harm's way. Tell them you want an attorney. You're not going to talk to them, etc. Just distance yourself from them, back it up. And they get very aggressive, especially when it's young children, which with the statistic I just gave you, about 44% increase in the deaths of young children. It's ironic that they'll give the children back to crackheads. But if you're a parent who's standing up for medical freedom or rights or things that you don't want to do, or if you don't want to engage with them, like making a choice, not just like I'm a drug addict, I'm not here. They are irate instantaneously. I had a client where they sent the cops out after him, had to put mom and baby with burner phones, like had to have them flee the state. I mean, it was wild, the most wild thing I've ever seen. So be very careful with DCYF, and that's why I say with spanking and stuff, just if you can stay clear of that. Even the Department of Health, any licensing body, stay clear of them. If they show up to your door, don't let them in, don't talk to them, call somebody, me or someone else. Yes, sorry, go ahead. Do you want to? Yeah.
If I as a Christian, don't get hired by a secular company, is there a legal difference between that and a Christian company not hiring a secular?
Yes. The difference is they don't care if you don't get hired. They care if a non-religious person doesn't get hired. What we have found for Christians in particular is they often don't get hired, or they'll get fired because of their religious beliefs. But in the hiring process, it's almost impossible to prove what, the discrimination was the intent. It's easy just because of I would say the temperature of our nation. It's easier to prove with race discrimination, gender, pregnancy, things like that. But we've tried to get a few cases going, and because you don't have any information on this end of why you weren't fired, unless they speak it to you directly. We're not hiring you because you're a Christian, you're not a good fit. It's almost impossible to prove it if they don't say it, or if there isn't, written communication, and you don't know if there's written communication until you get into it, and they'll probably get dismissed before you can. If it's a public place of employment like the state, you can do a public records request and see if there's any information ahead of time. Private employers, not so much. So, yes, any other, yes.
We're over on time.
I know, sorry, you guys can go ahead.
Yeah,
I don't,
we're
yes,
over on
I can
time.
answer.
So 501c3, like
Yes.
you said, what if you're not